In state court, if you're arrested for a crime which is not punishable by a maximum of life in prison, then you're entitled to bail as a matter of right. What that means is that when you go to the jail, there's going to be a standard bond that you'll be permitted to post. And you can go ahead and contact a bail bondsman or a family member and arrange for that bond to be posted and secure your release from jail without going in front of a judge. Now, there are certain exceptions to that rule. For instance, if you're charged with a domestic violence offense, you cannot bond out of jail before you see a judge, because there's a requirement in the law that the alleged victim of a domestic violence situation needs to be advised and notified that you're having a bond hearing and that you may be released from jail. And that's just one exception, although there are several. On the other hand, if you're charged in federal court, which is the United States of America versus the defendant, you cannot be released from custody without going in front of the judge and having a hearing. Now, in federal court, there are several different types of bail bonds. The first type of bail bond is what we call a personal surety bond. And what that means is that you'll agree on a specific dollar amount with the prosecution and present it to the judge. And if the judge accepts it, let's say a $50,000 personal surety bond, you and perhaps a co-signer will have to complete some paperwork. And once that's all submitted and approved by the judge, you'll be released. There's also a bond in federal court called a corporate surety bond, which requires that you post 15% of the bond before you can be released from custody. So for an example, if you get a $100,000 corporate surety bond, then you would have to pay $15,000 to a bail bondsman before you can be released from jail.